his writings that this power was intended to be diluted, that it was to be balanced amongst the chambers, that the judicial branch was viewed as the weakest of the three branches of government, not because it wasn't equal in power, but because it didn't have some of the mechanisms that the other two branches do to protect it. And while the president makes that appointment, it is this chamber, the sole duty of this chamber in the Constitution, to agree or disagree with that nomination. We saw that disagreement occur in 2016, where this chamber did not give its consent to a nomination. Later, Neil Gorsuch, Colorado's Neil Gorsuch, was confirmed to the Supreme Court. And just a matter of a little more than a month ago, we lost a trailblazing leader in Justice Ruth Bader Ginsburg, leaving open another seat on the Supreme Court that we are now asked to fill. Federalist 78, also written by Alexander Hamilton, has been referenced many times on the floor and this past year, and particularly during this debate. Wrote about the Constitution being fundamental law, that it's the will of the people, and that the courts are the only true guardians. The only true guardians of the Constitution, that the Constitution is the highest man-made law, that any legislative act to the contrary must be held void by the courts, since, and I quote, "the interpretation of the laws is the proper and peculiar province of the courts." That it was the guardian of the Constitution. When Madison was talking about this in the first Congress, he introduced, of course, the amendments that became what we call the Bill of Rights today. He said that the courts would, quote, "consider themselves in a peculiar manner the guardians of those rights. They would be an impenetrable bulwark against every assumption of power in the legislative or the executive. They will be naturally led to resist every encroachment upon rights expressly stipulated for in the Constitution by the Declaration of Rights." And that idea of this guardians of the Constitution that the court plays is a hallmark of our democracy today. And whether or not a justice has the support of a member of this chamber, I don't believe that anyone would deny that role that our courts must play. And that is that role as guardian of the Constitution. But it is clear in the confirmation hearing for Judge Barrett that some people believe the guardian of the Constitution takes on a different hue, that there is more to that role than simply looking at the law and making a decision based on the law. As some called it, I believe it was Justice Scalia, and perhaps paraphrased by Justice Gorsuch, that a judge's role is to call balls and strikes. I would add to that, it is not their role to call the pitch. But what we saw during the Judiciary Committee hearings, of course, was a viewpoint of some that a judge should be more than calling balls and strikes. A judge should be, in effect, a super legislator, that a judge should accomplish things that this chamber, this Congress, has failed to do, that if there is a shortcoming in a policy, that a judge or justice would look the other way and fill in that policy, or write that policy, or proactively create that policy. That, again, going back to what we have known throughout this country as the guardians of the Constitution. Guardians of the Constitution don't make up policy. They don't fill voids of new policies that the legislators didn't do or couldn't do because they couldn't get it through their chamber, so they decided they would count on a judge to do it somewhere else. That's not the role of the courts. It's certainly not the role of a guardian of the Constitution. A guardian of the Constitution is somebody who looks at the law and makes decisions of the law, upholds and protects that will of the people, the fundamental law of the people. And of course, an activist judge, an activist justice, would be reaching into the law to fit their own personal opinion or beliefs, to craft something that they believe is perhaps more in line with what they thought somebody wanted, more in line with their own opinions, instead of looking at that letter of the law. And I think it's important that we keep in mind that's not the role of the courts. If this chamber can't pass a policy or a law, if it can't have its own victory in carrying the day in an argument, it's not up to a judge or a justice to fill in the blank. They have to rule and carry out the law. And so that's a real key distinction that we saw during the Judiciary Committee debates. That role of policy maker that some wish Judge Barrett to be versus that role of protector, that guardian of the Constitution, calling balls and strikes. I look at any nominee for the courts, whether it's a district court or appellate court or a Supreme Court, through a lens of, are they going to protect that Constitution? Are they going to uphold the Constitution? Are they going to fight to defend it, that guardian of the Constitution? Are they going to protect and do the same with the law outside of the Constitution, the laws, the statutes that this body enacts, passes, signed into law by the president? Will that judge or justice uphold and defend that law? Not make that law, not change that law, but uphold the law. And of course, that guardian of the Constitution role that they will play. There's no doubt that Judge Barrett's qualifications are immense. Her qualifications as a member of our great American community, somebody with a beautiful family, it's mind-boggling. Jamie and I have a challenge with our 3 kids, making sure they get to school on time, making sure they're getting their homework done. I can't imagine 7 children while also carrying the schedule that their family does. But it's a testament to the incredible power and leadership of their family, their dedication to being upstanding citizens of this nation and giving back to this nation with this new pursuit. We know the keen intellect that has been shared with this country over the last several years in the Seventh Circuit Court of Appeals. We know her time as a law professor and have had the opportunity to look over a decade plus worth of work. And we know that she is a person of faith in our communities and has come under incredible attacks because of that faith. And we know in this chamber that our Constitution actually forbids the kinds of attacks that we have seen on her faith. Our Constitution makes it clear there is no religious test. Our Constitution actually makes it very clear that you cannot vote or deny public service appointment to someone because of their religious beliefs. We've seen it done, we've seen it tried, especially over the last Congress. We saw it done at the Budget Committee with the nomination of Russ Vought to be the Deputy Director of the Office of Management and Budget. When a colleague of ours basically said, because of his deeply held Christian beliefs, that he was not qualified to be a public servant in this country. And I hope the American people are hearing what is happening in some of these debates, that Amy Coney Barrett is attacked because of her faith, but it's not just limited or isolated to her. There are others who are more and more accustomed or who feel more and more empowered, emboldened to use a person's faith to deny them their vote to a position in our government. That is an unconstitutional test that some in this chamber are starting to rely on. And I hope the American people will use this opportunity to see through it, to reject it, and to get back to the values of our Constitution and the intent of that language. I had a conversation with Judge Barrett, the chance to visit with her, and I talked about those 3 qualifications to uphold the Constitution. Will you fight to protect the Constitution? Will you protect the law? And will you avoid being that activist legislator? Will you avoid legislating from the bench? And received her commitment that is exactly the kind of judge that she will be somebody to be that guardian of the Constitution, the protector of the law, to call balls and strikes. I talked to her about the importance that I know that the vote that I cast for her is something that matters not just next year or the next year, but 10 and 20 years from now, as she is on that court, that same view will remain. And she assured me that it will, because of the same reason that I want it to. That's the future of our kids and their kids. And she knows it means everything to her children as well, to protect our nation's laws and Constitution and to avoid that attempt, that desire, that pull at the heart to legislate, even if you want to come out with an opinion that is different than your own interpretation of the law. You have to follow the law. And that's what she has assured me she has done. She has assured me that there are moments and rulings that she has issued that she would have preferred a different outcome, personally. But that's not what the law required. And that's why she ruled the way that she did. In talking to my colleagues on the Judiciary Committee, they talked about her understanding of the law, and watching the hearings, you could sense the deep commitment and devotion to the law. There was a time several decades ago when President Ronald Reagan went to introduce Justice Sandra Day O'Connor to a group of federal judges at the White House. And Ronald Reagan, in his speech, talked about what it means to be a judge. He talked about the exacting standards of integrity, fairness, and intellect that's required for a federal judgeship, that it provides reassurance to all of us that our ideals of liberty and justice are alive and well. He went on to talk about the most important quality that we could have in a judge, and that was wisdom. That wisdom is the quality that we look for most. And I think you can sense the great deal of wisdom in Amy Coney Barrett. He went on to say that we demand of our judges a wisdom that knows no time, has no prejudice, and wants no other reward. We entrust judges with our ideals and freedom, and our future depends on the way that judge defines it. It requires the lonely courage of a patriot. And he went on to say that a judge is a guardian of freedom for generations yet unborn. And so I hope that my colleagues will support the nomination of Amy Coney Barrett. If you could take the politics out of the place, she would probably have a unanimous vote. Unfortunately, the politicization of this nomination is going to prevent that. But I just urge my colleagues to look past the politics, to look past the partisanship, and to vote for a truly qualified justice who is committed to the law, to the Constitution, who is committed against activism on the bench, and who will make sure that our country, for generations to come, has a protector, that guardian of the Constitution, with the wisdom to get the job done. I urge my colleagues to support Justice Amy Coney Barrett, and I am honored in just a few hours to know that I will be able to cast a vote in support of Justice, soon to be Justice, Amy Coney Barrett. Mr. President, I yield the floor. Senator from North Carolina.
Thank you, Mr. President. Mr. President, I ask unanimous consent that my full statement be added to the record.
Without objection.
Thank you, Mr. President. My staff, I want to thank my staff, Elliot, who's here on the floor, Brad, Cirillo, Seth, and Brad for all the work that they've done as we've gone through the nomination process. And I was reviewing my prepared remarks this morning, and then I was reflected back on a very important moment during the Judiciary Committee hearing where Senator Cornyn asked, he said, if you can see among all of us, we have 3-ring binders, we have staff behind us, we've taken weeks to prepare, and you're about to go through some 20 hours of questions. Would you mind sharing with us your notes? She lifted a blank notepad that was given to her by the chairman. It had nothing on it. She came to that committee fully prepared to answer any question from the 22 members of the Judiciary Committee, purely from what's up there. And she did an extraordinary job. The reason she did an extraordinary job is because she's had an extraordinary career, both as a student, beginning as a student, then going to Rhodes College, where she was magna cum laude, then going to Notre Dame School of Law, where she graduated first in her class. She went on to be a professor at Notre Dame, and she was multiple times voted the distinguished professor by a broad spectrum of liberal and conservative students. She's also proven as a judge with some 600 cases going through the Seventh Circuit that she has an encyclopedic knowledge of that law. There were so many times when members on the other side of the aisle would try and trip her up or ask her a question. She had no notes to refer to. She got the specifics of the case right, and what she demonstrated throughout the entire hearing process, which I attended, was that she does her job by doing two things: looking at the plain letter of the Constitution, understanding the limits of that the laws can have within the bounds of the Constitution, and rule accordingly. Now, my colleagues on the other side of the aisle in Judiciary Committee were constantly, it was clear to me, after weeks of attacking Amy Coney Barrett, not directly, but through surrogates, that they were trying to demonize this person before they ever came before the committee, like they did with Justice Kavanaugh. But each and every time they asked her a question, she brought them back to the boundaries of the Constitution and the question of law before, in her case, the circuit court. And there was just no way to trip her up. So then what happened? Then they started talking about how you're going to go to the Supreme Court and you're going to overturn the Affordable Care Act. They asked her questions that they knew she couldn't answer, and Justice Ginsburg, pursuant the Ginsburg rule, they have no intention, no responsible judge would go before the Judiciary Committee and tell you how they're going to rule on a future case. It's actually a violation of their code of conduct. So she told them in so many instances, and what was interesting with some of the members on the other side of the aisle was, on the one hand, they would say you cannot overturn this president or that president. And in the same breath, they would say, but we want to make sure you overturn this president or that president. And every time, Amy Coney Barrett was calm and composed and demonstrated to everybody in that committee that she's going to be objective, she is going to be fair, and she is going to stay within the lines of the Constitution and the matter of law that's before her. Now, I think that it's very important to have a judge like that on the Supreme Court. Our religious freedoms are at stake. Our Second Amendment rights are at stake. We do have people that want activist judges. I don't want an activist judge, period, not for a conservative cause or a liberal cause. I want a judge that I know if I someday go before the Supreme Court or any American, I want to know that I have a judge there who's going to be fair, who's going to be thoughtful, who's going to be impartial, and will always have a concern for both sides of the argument, but at the end of the day, know that they have a responsibility to judge objectively. Now, Mr. President, I've had a couple of opportunities to meet with Amy Coney Barrett. And the last meeting that I had with her in the Capitol, just a few steps away from where we are right now, I brought 2 pocket constitutions with me. And I said, I have 2 granddaughters. One will be 3 next week. The other one's a little over 2 months old. And I said, would you mind signing these constitutions for Sawyer and Willow, my granddaughters? And she said, certainly. She opened it up and she signed their name and just said, dream big. When they get a little bit older, not old enough yet, I'm going to get them to understand, excuse me, the significance of that quick note from an incredible jurist, somebody who dreamed big and realized her American dream, a mother of 7 school-age children, 2 adopted from Haiti, 1 with special needs. She's going to be the first Supreme Court justice female on the Supreme Court with school-age children. She has 7 of them. She's able to manage the stresses and the challenges of being a working mom while she served with distinction on the 7th Circuit, while her husband works as well. She's realized her American dream. I believe that she's going to make sure that everybody else has the freedoms to do the same thing. I think Judge Amy Coney Barrett is going to go down in history as one of the great justices on the U.S. Supreme Court. It is a shame, as you just said in your comments a moment ago, that this is even a divided decision. In a less political time than we find ourselves today, I suspect that she'd have the unanimous support of this body, much the same way that Justice Ginsburg did when she came before the Senate. But today, I'm looking forward to voting for Judge Amy Coney Barrett. I'm looking forward to watching her build on what's already a very strong legacy. I'm looking forward to making sure that we continue to have a court that's independent, impartial, focuses on protecting all of our constitutional rights and freedoms. And I know, without a doubt, Amy Coney Barrett is going to be one of those stewards in the U.S. Supreme Court. Thank you, Mr. President.
Mr. President.
Senator from Maryland.
Mr. President, I rise in opposition to the pending confirmation vote of Amy Coney Barrett to be an Associate Justice of the Supreme Court, to fill the vacancy created by the death of Justice Ruth Bader Ginsburg, who we lost in September of this year. Justice Ginsburg was a champion of women's rights and civil rights, and she is going to be sorely missed on that court. Article 2, Section 2 of the Constitution provides that the President shall nominate and by and with the advice and consent of the Senate shall appoint judges of the Supreme Court. One of the Senator's most solemn responsibilities is to evaluate the nominees' qualifications, as well as the process the Senate uses to provide their advice and consent for a lifetime appointment to our highest court. I believe on both substance and process, this nomination should be rejected. First, on process. Let's talk about fairness. Let's talk about the integrity of the Senate. Let's talk about living up to your own words. Let's talk about using the same rules for Republicans that you used for Democrats. Let me remind my colleagues what happened in 2016 in the Senate during President Obama's final year of a term in office in a presidential election year. Justice Scalia died in February of 2016. Within just a few hours after the death of Justice Scalia, Leader McConnell unilaterally announced that the Senate would not consider a replacement for Justice Scalia until after the November 2016 presidential elections, which established a year-long vacant Supreme Court seat. The Republican leader's action, backed by his caucus, set a very clear precedent. Under no circumstances do Senate Republicans consider a Supreme Court nominee in a presidential election year. It did not matter that in March 2016, President Obama appointed Merrick Garland, a respected D.C. Circuit judge with bipartisan support. They would not meet with Judge Garland, hold a hearing, or allow a vote on him for 293 days. In 2016, the presidential election was nearly 9 months away. 4 years ago, our Republican colleagues said 9 months was not time enough. Leave it up to the voters. We will do this whether it's a Democrat or Republican in the White House. The Republican leader, Mitch McConnell, said, and I quote, "Mr. President, the next justice could fundamentally alter the direction of the Supreme Court and have a profound impact on our country. So of course, the American people should have a say in the court's direction. The American people may well elect a president who decides to nominate Judge Garland for Senate consideration. The next president may also nominate somebody very different. Either way, our view is this: give the people a voice in the filling of this vacancy. The American people are perfectly capable of having their say on this issue. So give them a voice. Let's let the American people decide. The American people should have a voice in selection of the next Supreme Court justice. Therefore, this vacancy should not be filled until we have a new president. That was the Republican leader. Several Judiciary Committee members made similar statements after the death of Justice Scalia. Senators Grassley, Graham, Cornyn, Lee, and Cruz signed a letter to Leader McConnell, which read in part, "We are in the midst of a great national debate over the course of our country will take in the coming years. The presidential election is well underway. Americans have already begun to cast their votes. As we mourn the tragic loss of Justice Scalia and celebrate his life's work, the American people are presented with an exceedingly rare opportunity to decide in a very real and concrete way the direction the court will take over the next generation." The letter from my Republican colleagues concluded, "We believe the people should have this opportunity because our decision is based on constitutional principle and born on the necessity to protect the will of the American people. This committee will not hold hearings on any Supreme Court nominee until after our next president is sworn in on January 20th, 2017. Current Judiciary Committee Chairman Graham explicitly addressed this point in 2016. In March 2016, Senator Graham, then a member of the Judiciary Committee, said, "I want you to use my words against me. If there's a Republican president in 2016 and a vacancy occurs in the last year of that first term, you can say, Lindsey Graham said, let the next president, whoever it might be, make that nomination, and you can use my words against me." And you would be absolutely right. We are setting precedent here today. Republicans are, that in the last year of a presidential term, that you're not going to fill a vacancy on the Supreme Court based on what we're doing here today. That's going to be the new rule. And I've repeatedly stated the election cycle is well underway, and the President of the Senate is not to confirm a nominee at this stage in the process. And by the way, Senator Graham reaffirmed that in 2018. In the case of Justice Ginsburg's death and vacancy in 2020, we are about 40 days away from a general election, not 9 months. And mail-in voting in record numbers have already begun in several states. And of course, early voting has started in many states also. We are proceeding to a final vote on this nominee for a lifetime appointment just days before Election Day. And millions of Americans have already cast their ballots. Once again, within an hours of Justice Ginsburg's death, Leader McConnell unilaterally decreed that the Senate would fill the vacancy before the election. Leader McConnell said that President Trump's nominee will receive a vote on the floor of the Senate. So I implore my Republican colleagues to stop this blatant hypocrisy now. Let's follow the McConnell rule and let the American people pick the next president and Senate so they can weigh in on this decision, just as Senator McConnell argued in 2016 when President Obama nominated Merrick Garland for Justice Scalia's seat. Let the Senate honor Justice Ginsburg's legacy by continuing to fight for the rights she fought for her entire career, both as a litigator, circuit judge, and finally as a Supreme Court justice. Let us honor Justice Ginsburg's dying wish. My most fervent wish is that I will not be replaced until a new president is installed. President Trump's agenda is quite clear when it comes to his strategy for the Supreme Court. President Trump has repeatedly said he would appoint justices in the mold of Justice Scalia. As President Trump said on the campaign trail, when asked what kind of justice he would nominate, we're going to have a very strong test. We want a strong conservative people that are extremely smart. Scalia is a terrific judge. Clarence Thomas, you look at him. He's been a stalwart. He's been terrific, and we have others. President Trump also talked about the type of justices he did not like when he went on the campaign trail. He said, "I'm disappointed in Roberts because he gave us Obamacare. He had 2 chances to end Obamacare. He should have ended it by every single measurement, and he didn't do it. So that was a disappointing one." Everybody thought he was good. He was a Bush appointee. He was somebody that should have, frankly, ended Obamacare, and he didn't. When President Trump announced Judge Amy Coney Barrett's nomination to the Supreme Court, Barrett herself highlighted the ideological parallels between her and her mentor, Justice Scalia. She said about Justice Scalia, his judicial philosophy is mine too. Judge Barrett was a Supreme Court clerk for Justice Scalia. Justice Scalia was one of the most staunchly conservative members of the Supreme Court. Justice Scalia voted to strike down key parts of the Affordable Care Act. He frequently called for overturning Roe v. Wade. He opposed marriage equality. He voted to gut the protections in the voting rights in the Shelby case. He voted to gut our campaign finance laws in Citizen United case. He made it harder for workers who were discriminated against by their employers to seek justice in court, and further stacked the deck in favor of wealthy business owners and corporations over working class individuals. By nominating Judge Barrett, President Trump is attempting to bring Justice Scalia's judicial philosophy back to the mainstream and our nation's highest court. Placing Judge Barrett on the Supreme Court puts at risk so many of the rights and protections Americans have fought for and gained. So let's look how the law could change if Judge Barrett is confirmed. That's the second reason to oppose this nomination, her judicial philosophy, in addition to the flawed process. You cannot always predict how a Supreme Court justice will act after her confirmation, but Judge Barrett has given us clear views on her philosophy. So many of the American rights are on the line, but let me start with talking about the Affordable Care Act. Judge Barrett has made her views quite clear about the Affordable Care Act. In 2017 Law Review article, she concluded that the ACA is unconstitutional. She wrote, Chief Justice Roberts pushed the Affordable Care Act beyond its plausible meaning to save the statute. Judge Barrett argued that the Chief Justice Roberts' approach to NFIB versus Sebelius, which was joined by Justice Ginsburg, expressed a commitment to judicial restraint by creatively interpreting ostensibly clear statutory language, and that its approach is at odds with the statutory textualism to which most originalists subscribe. In another Supreme Court case, King versus Burwell, the Supreme Court in a 6-3 decision, joined by Justice Ginsburg, affirmed health insurance tax credits for millions of families. Nearly 9 million Americans depend on these tax credits for coverage. Barrett criticized the decision, stating, I think the dissent has the better of the legal arguments. And elsewhere she wrote, Justice Scalia is criticizing the majority's construction of the Affordable Care Act and NFIB versus Sebelius and King versus Burwell, protested that the statute known as Obamacare should be renamed SCOTUS Care in honor of the court's willingness to rewrite the statute in order to keep it afloat. By this measure, it is illegitimate for the court to distort either the Constitution or a statute to achieve what it deems a preferable result. It's clear to me, and it should be clear to all of us, that Judge Barrett has a clear bias against the Affordable Care Act. President Trump has repeatedly stated that he would appoint judges who would overturn the ACA, and has consistently done so in terms of his appellate and trial court nominations. Judge Barrett appears to meet President Trump's litmus test. I mention these cases to underscore the importance of the Supreme Court justice in the lives of all Americans. So much is at stake in the filling of Justice Ginsburg's vacancy. Your health care is literally on the line. The Affordable Care Act that President Trump has tried to repeal, and the Republicans tried to repeal in this body, but have failed, they're now going to take it to the Supreme Court. A hearing is scheduled this November 10th in the case of California versus Texas, just 1 week after the general election. This is a real risk for tens of millions of Americans who depend on the law for their health care coverage and other benefits. 20 million Americans could lose their health care, and people with pre-existing conditions could lose those protections. That's 133 million Americans during the corona pandemic. That's what is at stake. We are talking about pregnancy, cancer, diabetes, high blood pressure, behavioral health disorders, high cholesterol, asthma, chronic lung disease, heart disease, and numerous others that have been held to be pre-existing conditions before the protection in the Affordable Care Act. And you can now add COVID to those preconditions for 8 million Americans and counting. That protection is in the Affordable Act. This is on the line before the Supreme Court this November. If the Affordable Care Act is struck down, insurers could bring back annual and lifetime limits on coverage. Adults coverage by Medicare expansion will lose vital health services. Young people would be kicked off of their parents' insurance, and insurers could sell skimpy plans that don't even cover essential health benefits like prescription drugs or emergency room visits, mental health, and substance use and maternity care. The Affordable Care Act increased access to care for millions who were previously uninsured or underinsured. Through Medicaid expansion, 13 million low-income Americans now have dependable, comprehensive health coverage. In Maryland alone, over 1.3 million low-income individuals depend on Medicaid, including 512,000 low-income children, 107,000 seniors, 152,000 individuals with disability. That is just in Maryland. We must protect the Medicaid expansion population and other uninsured and underinsured populations from the Trump administration's effort to eliminate their access to affordable care. It is at risk. I have similar concerns about women's health care issues. Judge Barrett has already gone on record in opposition to reproductive rights and freedom, so it's clear to me that she would try to roll back the clock on those rights as a Supreme Court justice. In a 2013 speech she entitled Roe at 40, Judge Barrett explained that Republicans are heavily invested in getting judges who will overturn Roe. She wrote that the framework of Roe is essentially permitted abortion on demand, and Roe recognizes no state interest in the life of the fetus. In a 2003 article, Judge Barrett suggested that Roe v. Wade was an erroneous decision. Recall that President Trump has already said he would only nominate justices who would automatically overturn Roe v. Wade. Judge Barrett appears to have met this litmus test as well. Indeed, Judge Barrett may hold an even more extreme record when it comes to reproductive rights than I've already stated. She refused to say at her confirmation hearing whether Griswold versus Connecticut was rightly decided, in which the court held that the Constitution guarantees a right to marital privacy and that a law criminalizing the use of contraception violated that right. Now note that Justices Roberts, Alito, Kagan, and Kavanaugh all discussed the Griswold case at their confirmation hearing. Yet Judge Barrett said that the Griswold's correctness, quote, is something I cannot opine on. Judge Barrett's views on immigration also raises concerns. Our most vulnerable individuals are at risk, as well as with the naming of a new justice to the Supreme Court. Let me talk about one specific group. On June 18th of this year, in a 5-4 decision written by Chief Justice Roberts and joined by Justice Ginsburg, the Supreme Court held that the Department of Homeland Security violated law when it rescinded the Deferred Action for Childhood Arrival DACA program. There are approximately 643,000 DACA recipients. These are our dreamers in the United States. And approximately 29,000 are healthcare workers, essential workers, who are serving us during COVID-19 pandemic, who have saved lives and eased suffering. But for the 5-4 decision, those individuals' lives could have been totally disrupted, and they could have been ordered to leave our country. These are individuals who know no other home but the United States of America. They're our neighbors and friends. The next justice could very well determine the fate of the dreamers. Unfortunately, Judge Barrett already has demonstrated a judicial track record which is hostile to immigration. In Cook County versus Wolf, Judge Barrett authored the dissenting opinion from a ruling that struck down the Trump administration's cruel public charge rule. The rule basically penalized immigrants for exercising their legal rights to use benefits that Congress has made available. And in the case of Yafai versus Pompeo, Judge Barrett wrote the majority opinion and held that the U.S. consular officials have virtually unchecked authority to deny visa applications to those seeking entrance to the United States. It was pointed out in the minority opinion that the majority has created a constant, dangerous abdication of judicial responsibility that would lead immigration officials to deny visas on the basis of impermissible bias. So let me turn to the rights of the LGBTQ community. In the Oberfeld versus Hodges case, joined by Justice Ginsburg, the Supreme Court held that the Constitution guarantees same-sex couples the right to marry in a 5-4 decision. Unfortunately, Judge Barrett has demonstrated hostility to marriage equality and the LGBTQ rights more generally. In speeches, Judge Barrett seemed to be critical of the Supreme Court's decisions in Oberfeld, indicating she was worried about the who decides question when it comes to the courts or legislature deciding who can marry and start a new family. But fundamental rights under the Constitution should not be up for debate. Every American should have the same rights, benefits, and obligations of marriage, regardless of their gender or who they love. Notably, Judge Barrett referred to sexual orientation as sexual preference in her testimony, implying that sexual orientation is a choice instead of an immutable characteristic. As Justice Kennedy concluded in Oberfeld, no union is more profound than marriage, for it embodies the highest ideals of love, fidelity, devotion, sacrifice, and family. In forming a marital union, two people become something greater than once they were. As some of the petitioners in this case demonstrate, marriage embodies a love that may endure even past death. It would be misunderstood, these men and women, to say they disrespect the idea of marriage. Their plea is that they do respect it so deeply that they seek to fulfill its obligations themselves. Their hope is not to be condemned to life of loneliness, excluded from one of civilization's oldest institutions. They ask for equal dignity in the eyes of the law. The Constitution grants them that right. I hope we agree with Justice Ginsburg, but I'm afraid that's a view that is not shared by Judge Bennett. Judge Bennett was critical as well as the extension of civil rights laws to protect transgender people, saying at an event that it does seem to strain the text of a statute to say that Title IX demands it. However, the Supreme Court held otherwise in Boxstead versus Clayton County, where Justice Gorsuch, joined by Justice Ginsburg, held for the court in a 6-3 decision that prohibition of employment discrimination on the basis of sex should read to include gender identity and sexual orientation. Judge Barrett has issued several disturbing findings that indicate a cramped and narrow view on civil rights laws designated to protect American workers from discrimination based on race or age. In EEOC versus AutoZone, Judge Barrett voted against rehearing a panel decision that ruled against an African-American employee whose company involuntarily transferred him to another store based on race. The EEOC had charged that AutoZone had an unlawful practice of segregating employees by race when it assigned African-American employees to stores in African-American neighborhoods and Latino employees to Latino neighborhoods. The dissent argued that the court upheld a separate but equal arrangement that is contrary to the Supreme Court's decision in Brown v. Board of Education, when the court interpreted the Equal Protection Clause of the 14th Amendment to find that separate facilities can't be equal. The dissent wrote, "The case presents a straightforward question under Title VII of the Civil Rights Act of 1964. Does a business policy of segregating employees and intentionally assigning members of different races to different stores tend to deprive an individual of employment opportunities on the basis of race?" The panel answered this question, no, not necessarily. I cannot agree with that conclusion. Once again, Judge Barrett was on the side of denying protection against racial discrimination. In Kleiber versus Care Fusion Corporation, Judge Barrett sided with the majority that Age Discrimination and Employment Act only protects current employees from discrimination due to disparate impact and not outside job applicants, a very narrow view. And then there's Judge Barrett's views on gun safety that I find deeply concerning. Judge Barrett's record strongly suggests that she would strike down common sense gun safety laws, even as Congress and the states continued to try to combat gun violence, which kills nearly 40,000 Americans every year. According to the Center for American Progress, from 2008 to 2017, Over 6,200 people were killed with guns in Maryland. And from 2014 through 2018, there were 42 mass shootings in Maryland, killing a total of 45 people and injuring 156. That's just in one state. The next Supreme Court justice could hold the decisive vote should Congress or the states adopt common sense gun safety laws to curb gun violence, such as requiring universal background checks, banning assault weapons, or banning high-capacity magazine clips. In Cantor v. Barr, the Seventh Circuit held that a law barring felons from possessing a firearm did not violate the Second Amendment. The Supreme Court previously held in the District Court versus Heller that the Second Amendment conveyed an individual right to bear arms separate from the right of the militia to do so. Even Justice Scalia, Judge Barrett's mentor and President Trump's role model for an ideal justice, wrote in his majority opinion for the court in Heller that nothing in our opinion should be taken to cast doubt on the long-standing prohibition on the possession of firearms by felons. Yet Judge Barrett's dissent in Cantor and concluded that the bar on gun possession should only apply to violent felons. She argued that the majority was treating the Second Amendment like a second-class right. She went on to note that the government could deny nonviolent felons the right to vote, but not the right to bear arms, because history does show that felons can be disqualified from exercising certain rights, like the right to vote and serve on juries, because these rights belong only to virtuous citizens. So ultimately, Judge Barrett bizarrely seems to treat voting rights as a second-class right compared to gun ownership. That's pretty extreme. I've always